All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
There seems to be an indication that Ms. Adeboyejo is continuing, or is Mr. Gampert continuing? No, because you are still sitting, Mr. Gampert. Because of that, I was a little bit. But you have still the floor, of course.
I'm grateful. Your Honours, there are two matters related to duress, the workings of Article 31(1)(d) of the statute, arising from the defence's closing brief, that I want to deal with. First, the defence's claim that escape was nearly impossible from the LRA and that failed attempts would be punished by death. And second, that at no stage in the brief do the defence attempt what the prosecution say is necessary, a demonstration that there is evidence that Mr. Ongwen was under duress at the specific time when he is alleged to have carried out each of these alleged crimes. Let me deal with escape first. Why is it relevant to duress, and was it, to quote the defence, nearly impossible? The prosecution submits that in order for the Chamber to avoid holding Mr. Ongwen responsible for crimes which it otherwise finds proven on grounds of duress, there must be a showing that a person who carried out the actus reus of the crimes against his own will and only because he was under threat. And such a person, we submit, can be expected to take steps to escape from that threat as soon as possible. No reasonable person who has been forced to murder, rape, abduct innocent children would voluntarily stay within the power of the person who had so forced them for a moment longer than they had to. The evidence demonstrates that there were many opportunities for Mr. Ongwen to escape. He could have escaped when he was on mission, during battles, or simply when the units that he commanded were hundreds of miles away for days and weeks from Joseph Coyne and the LRA leadership. Thousands of LRA members of various ranks left the group, escaping successfully when the opportunity arose. Defence witness D134 testified, and I quote, "LRA fighters would escape every day." The escapees varied in profile. There were lower ranking fighters, senior commanders, children, forced wives of LRA commanders. Your Honours have heard directly from a total, as I calculated, of 50 witnesses who escaped from the LRA in a range of circumstances. D60 and threatened with death after 2 unsuccessful attempts. Battalion Commander P245 escaped. Brigadiers Sam Kolo and Caesar Achelam, senior in rank to Mr. Ongwen at the time when he committed the crimes we allege against him. They found their own ways to leave the bush. Testimony from several trial witnesses and other evidence demonstrates that Mr. Ongwen was the most senior LRA commander remaining in Uganda in 2005. There was by then no one in a position to prevent him from leaving the LRA. He only left that organisation, we suggest, when he could see that there was no more future for him in it. The defence have repeatedly claimed that failed escape attempts will be punished by death. But the evidence demonstrates that although there were threats of that punishment, they were not regularly implemented. The intercept evidence demonstrates the reaction of Joseph Coyne and his deputy, Vincent Otti, when escapes were reported to them. It demonstrates their feelings of frustration and impotence in the face of constant escapes. Joseph Coyne is captured at one stage, accepting that, in reality, any punishment for escape would be, as he put it, in the hands of God. What of the defence's claim that in the event of successful escape, the LRA would kill the escapee's whole family? You have heard accounts of collective punishment occasionally being implemented in the 1980s and the 1990s, but no suggestion that by the time Mr. Ongwen was in a senior position, the escape of a senior commander resulted in such punishment. Many long-term members of the LRA testified about how their perceptions of the LRA, of its disciplinary procedures, and particularly of the roles of spirits and the powers of Joseph Coyne changed significantly between when they were first abducted and after they had stayed with the LRA for some time. Witnesses P379, P309, P85, P209, P200, defence witnesses D92, D56, D27, all explained to Your Honours how they had grown increasingly sceptical of Joseph Coyne's purported spiritual powers, and that they understood that the consequences for violating the rules of the LRA were by no means absolute. All those witnesses subsequently took the positive decision to escape, and
Yeah, Mr. Gambert, you have heard it. Please slow down a little bit.
I think I need not repeat, perhaps. No. Those witnesses that I identified a moment ago, they all took that positive decision to escape, and they carried that decision out. The second matter, indeed my last matter on which I will be addressing the court. Duress is not a blanket defence. It's crime-specific. The text of the article of 31(1)(d) makes it clear that it is threat and crime-specific. The terms of the text of the article are consistently in the singular. It speaks of a crime, a threat, this threat, and a greater harm in the singular form. Case law from the International Criminal Tribunal for Yugoslavia, the case of murder, and at the E CCC supports that interpretation, the case of Duik. The defence has made no attempt to analyse the circumstances of each charged crime, or to demonstrate how the alleged duress applies to that specific crime. Instead, the prosecution suggests the defence hopes to persuade the Chamber by making general, broad assertions about the violent environment of the LRA, about Joseph Coyne's control of the group, and about the role of spiritualism. What was it, to take an example, that prevented Mr. Ongwen, when he led his fighters to the camp at Odek, knowing that the attack would result in civilian deaths, abductions of children, destruction of people's homes, and widespread terror? What prevented him from hailing the government forces there and explaining that he and the fighters under his command wanted not to attack the camp, but to put down their weapons and surrender, like so many LRA fighters, many of them senior commanders like Mr. Ongwen, had done before them? What was it, to echo something which Mrs. Adeboyejo said a little while ago, what was it when the little girl who became witness P226 was finally brought to his quarters, which prevented him from quietly explaining to her that he didn't want to rape her and that all they had to do was to lie down quietly together and wait until the morning? To borrow, if I may, the words of the pre-trial chamber at paragraph 153 of the decision confirming the charges in this case, and I quote, "Duress is not regulated in the statute in such a way that will provide a blanket immunity to members of criminal organizations which have brutal systems of ensuring discipline as soon as they can establish that their membership was not voluntary." Well, those are my submissions, and I hand over now to Mr. Black.
Your Honors, I'll address a number of topics today, all of which have to do with the charged attacks. Now, we've written about each of those attacks, in our closing briefs. And of course, I won't repeat those submissions today. Instead, I'll focus on responding to the defense closing brief. Now, I'll address the attacks in chronological order, starting with the attack on Pajula IDP camp in October of 2003. Before I come to what the defense disputes about that attack, I think it's worth noting some of the things they don't appear to dispute. Nowhere in the defense's closing brief, as far as I can see, do they appear to dispute that the LRA attacked Pajula in October of 2003, or that the charged crimes were committed there. Now, they do dispute Mr. Ongwen's liability for those crimes, but they don't, in their closing brief anyhow, deny that they occurred.
So again, we have the problem, and the problem might also be that the structure of the language is English on the one side, which is a very concise and short language, and the other languages we have to translate to, which are perhaps a little bit, I would not say more complex, of course, but a little bit more prolonged when you speak it out. That might cause a little bit of a problem. So Mr. Black, same thing we had. Please try to slow down a little bit.
Thank you, Your Honor, and my apologies to the interpreters. I'm actually having difficulty with the headphones, but I'll go slowly. As I was saying, Your Honors, they do not appear in their closing brief to contest the fact that the crimes were committed, although they contest Mr. Ongwen's liability. They don't deny that Mr. Ongwen was together with Vincent O.T., the mastermind of this attack, in the days just before it. They don't dispute that Mr. Ongwen was present at the RV, the meeting before the attack, or that he was seen leaving that RV just before the attack. On all of those points, at least, it seems that the parties agree. I also note that for Pajule, at least, the defense have wholeheartedly embraced the prosecution's intercept evidence. They cite the logbooks over and over again as they relate to Mr. Ongwen's injury, his arrest, his position in the LRA, and even his participation or not in the attack. The defense even suggests that if we had an audio recorded intercept from this date, which we don't, but they suggest that if we did, it would be a reliable indicator of what Mr. Ongwen was doing on that day. And so you see my point here, Your Honors, is that when the intercept evidence, when the defense feel that's favorable to them, they consider it reliable, and they ask you to rely on it. It's only when the intercept evidence incriminates Mr. Ongwen that they question it or ask you to reject it. Let me come squarely now to the two main arguments the defense raise as to why they say Mr. Ongwen should not be responsible for the crimes committed during the Pajule attack. As I say, they appear to accept that Mr. Ongwen was with OT at that time, and that he was at the RV from which the attack was launched. But they say that Mr. Ongwen was, one, severely injured, and two, under arrest at the time, and consequently that he had no position or power in the LRA and could not plan or participate in the attack. The evidence shows the opposite. At this time, Mr. Ongwen had a significant rank. He was a major. He had recently been appointed to a senior position, 2IC of the Senior Brigade. And critically, Your Honors, he had been operational and active for at least 9 months following his injury in November of 2002, and 5 months since he was arrested briefly in April 2003. Let me address the injury first. It's undisputed that Mr. Ongwen was injured in November 2002. He suffered a leg injury. And he stayed for some time in an LRA sickbay. But let me make this point as clear as I can, because it's important. An LRA sickbay was not a hospital like we might think about it. In fact, it wasn't so much a place as it was a group of LRA fighters. Recall that at this time, the UPDF was hunting the LRA in northern Uganda. So by necessity, the sickbay moved around. It included armed fighters, injured fighters, as well as healthy fighters to help take care of them. They carried out operations, among other things, to get the food that they needed to survive. Indeed, a number of Oka Battalion fighters remained with Mr. Ongwen in the sickbay, some of whom came and testified in this courtroom. They said that despite his injury, Mr. Ongwen was the highest ranking person in that sickbay. Everyone else there took orders from him, and he continued to issue orders and to launch missions from December 2002 right up until he left the sickbay sometime in the summer of 2003. What exactly does the evidence show about how long Mr. Ongwen may have been incapacitated by his leg injury in November 2002? Logbooks show that already on the 6th of December 2002, he reported to COIN that he'd ambushed and burned a vehicle on the Kitgum-Gulu Road. P205 a longtime Senior Brigade member, confirmed Mr. Ongwen's ability to launch missions at this time. He said that while in sickbay, Mr. Ongwen would, quote, send people to work, end quote. And that in December of the same year he was injured, he sent people to collect cattle from Pajule. Witnesses who escaped in March of 2003, more than 6 months before the Pajule attack, and who had served with Mr. Ongwen in the sickbay, confirmed that when they left the LRA, he could walk. By April 2003, Mr. Ongwen was reporting that he and his men had ambushed vehicles and killed civilians. Specifically, on the 5th of April, he reported operations in Lajile, during which his group killed civilians and burnt civilian houses. According to witness P379, Mr. Ongwen was sufficiently healthy to deploy for that attack in person. There are more examples, Your Honors, with citations in our closing brief. My point is simply that Mr. Ongwen's presence in a sickbay did not mean that he was inactive, that he had lost authority, or that he had lost control of his fighters. To the contrary, he continued to plan and order attacks, and when healthy to go on those attacks himself all the way through 2003. I'll turn now to the question of Mr. Ongwen's arrest. Once again, there is no dispute about the fact that Mr. Ongwen was arrested in April 2003. The prosecution itself led evidence about this. Evidence that Mr. Ongwen and at least one other person were arrested, albeit briefly, around the 20th of April 2003, after they had apparently had contact with a senior UPDF commander named Salim Saleh. The defense argued that Mr. Ongwen remained under arrest from this time in April, at least up until the Pajule attack. But the evidence paints a completely different picture. On the 22nd of April 2003, just 2 days after his arrest, Mr. Ongwen reported on the radio to Coyne that he'd forgotten the location of some hidden arms and asked for directions. Shortly after that, he reported that he'd sent one of his commanders to go and retrieve them. On April 28th, Coyne instructed Mr. Ongwen to continue checking the Lajile area for remaining civilians and said that if he found some, he should, quote, just destroy, end quote. On the 26th of May, Mr. Ongwen reported attacking Opit. On the 7th of June, another commander, Lapaicho, told OT that the commander who attacked Opit was Dominic and that he had, quote, burnt all the camp mission and trading center. By the end of September 2003, Joseph Coyne himself singled Mr. Ongwen out for the, quote, hard work that he was doing. Coyne even suggested that if Abu Dema, who was then Senior Brigade commander, if he wasn't careful, someone else might be appointed command of that brigade. The implication seems to be, Your Honors, that that other person was Dominic Ongwen. And indeed, within months, he'd assumed that position. Again, there are more examples in the logbooks and in our closing brief. But suffice it to say that from April to September 2003, Mr. Ongwen was active, operational, sending men on missions, personally participating in operations, and earning the praise of his superiors, including the very man who'd ordered his arrest in April 2003, Joseph Coyne. This does not sound like someone who is still under arrest and who'd been stripped of command. It is consistent, though, with the evidence in this case. on the 22nd of September 2003, OT listed for Coyne his senior commanders in Uganda. He referred to Mr. Ongwen as Engineer Brigade, but like 4 or 5 others, he said he was, quote, without office, end quote. Coyne ordered OT to take all those commanders without office and to keep them with OT at headquarters. The defense has never suggested that those other commanders were under arrest, and yet they all were taken to OT. About 1 week later, 10 days before the Pajule attack, on the 30th of September, Coyne singled out Mr. Ongwen as someone who should stay with OT's group, and I quote, because he has good plans which can help OT, end quote. And indeed, within a week, Ongwen had joined OT's group, and within a week after that, Pajule was attacked. I would submit that the logbook evidence tells us exactly why Mr. Ongwen was with OT in October 2003. Far from being under arrest, Mr. Ongwen had been promoted to 2IC of Senior Brigade. OT was gathering people for an attack, and Joseph Coyne himself had recognized Mr. Ongwen's ability to help him with the planning. I'll turn now to the 29th April 2004 attack on Odek, although some of the points I'll make, I think, apply also to Lukoti and Abok attacks. In the next few minutes, I'll address 4 topics: direction finding, Mr. Ongwen's location on the day of the attack, the intercept evidence relating specifically to Odek, and the location of the pre-attack RV.
Mr. Black, please repeat the last sentence and slow down a little bit.
I'll address the direction finding, Mr. Ongwen's location on the day of the attack, the intercepts evidence relating specifically to Odek, and the location of the pre-attack RV. So first, direction finding. And you might be asking yourselves, what again is direction finding, and why am I discussing it during the prosecution's closing brief? After all, neither the prosecution nor the defense called a single live witness to tell you what direction finding is, how it works, how reliable it is. The only evidence on this topic appears in Rule 68 2B statements, which were submitted by the prosecution for a different purpose, because they address the intercepts program. We made clear when we submitted those statements that we didn't rely on direction finding. The defense likewise announced in filing 555, and I quote, the defense intends to challenge the processes in which the UPDF located persons on the radio and explain the deficiencies in the UPDF technique. This led... Still?
Yeah, again, I think I repeat it. It is difficult. You of course, you know what you have in mind, what you want to say, and you get carried away. And the presiding judge, one of those who also normally speaks very slow, so very quick, on the contrary, and has problems to speak slow. So I fully understand you, but please try to speak a little bit slower.
I apologize, Your Honor. I'm a serial offender here. So.
I would not go so far, but please observe this.
These positions of the parties, Your Honors, led you, in Decision 596, to conclude that the unreliability of the UPDF direction finding evidence was not disputed between the parties, and there was no reason to call live witnesses to talk about it. It's surprising, therefore, that the defense now, at the end of the case, rely quite heavily on direction finding. At paragraph 353 of their closing brief, the defense rely exclusively on direction finding data to plot Mr. Ongwen's alleged location 2 days before and 2 days after the Odek attack. In the context of Lukoti, at paragraphs 405 and 406, the defense argued that it would be impossible for a witness's recollection to be correct because they say, quote, it conflicts with contemporaneous data collected by the government of Uganda Directional Finding Program, end quote. Excuse me. Now, in fact, that evidence isn't incompatible, but my point, Your Honors, is that the defense, who before considered this information unreliable and full of deficiencies, has now hung its proverbial hat on this evidence. So back to my two questions. What is direction finding, and why am I talking about it if the prosecution doesn't rely on it? Very briefly, the term direction finding data refers to coordinates that were generated by the UPDF in an effort to locate LRA commanders during hostilities. Basically, and I hope I say this right, the UPDF would use electronic equipment to identify an LRA radio signal and try to determine from where that signal came. If they could do that from two receivers, they could triangulate the directions and estimate where the LRA signals originated from. If that was successful, of course, they just have radio signals. To know who was speaking, they asked the intercept operators, who was that? And the intercept operators gave the names, the identities of the commanders. And then the coordinates would be written down in UPDF intelligence reports, several of which are in evidence in this case. So that's what it is. But again, why am I talking about it? Well, let me be crystal clear. The prosecution is not changing its position. We're not now asking you to rely on this information to convict Mr. Ongwen. For one thing, as I've said, you don't have very much evidence about it and how precise or how reliable it is. But more importantly, even if it is reliable, it's limited in at least two important ways. First, the intelligence reports list coordinates for some LRA commanders on some days, not for every commander on every day. And we simply don't have coordinates for Mr. Ongwen for most of the days in the relevant period. We don't have coordinates for any of the days of the charged attacks. Second, even if we had coordinates for where Mr. Ongwen allegedly was, the direction finding tells us nothing about what he was doing. For that, we need other evidence. We need witnesses, or maybe logbooks, or intercept evidence. We do have that evidence, a lot of it in this case. And we think your honors can rely on that direct evidence rather than making suppositions based on the direction finding. But having said all of that, I feel that I must address the content of the direction finding data because the defense have suggested that it creates a reasonable doubt about Mr. Ongwen's ability to participate in the Odek attack. And for that reason, I'm going to show you what, if accepted at face value, the direction finding information would show about Dominic Ongwen's location between March and August 2004. Your Honors, on the screen is a map. This is a map of part of northern Uganda. It shows the sites of the 4 charged attacks. And as I'll show you in a moment, the prosecution has plotted the direction finding coordinates on this map. As I go through the coordinates, Your Honors, I'd ask you to keep 2 things in mind. First, I draw your attention to the light blue line, the river, that goes from the top left center of the map to the bottom right center. That's the Achwa River. The defense would have you believe that in April 2004, that river was crossable. And second, they suggest to you that Mr. Ongwen couldn't walk very far at this time. Now, there's a distance scale on this map. It's a bit small for me. But if you judge by the blocks with the dates of the attacks, each of those blocks is about equivalent to 10 kilometers. Oh, the grid is a 10-kilometer square, Mr. Gumpert educates me. Sorry, that was good. The first coordinates we have from this period are from the 10th of March, and they place Mr. Ongwen some ways north of Pajula. We have nothing for the next 2 weeks, but on the 25th of March, he is on the banks of the Achwa River, some, 10 or 15 kilometers north of Odek. On the 3rd of April, he has gone back to the east. And then, between the 3rd of April and the 6th of April, according to the direction finding evidence, he has covered some 40 or 50 kilometers to the west and crossed the Achwa River. This is less than a month before the Odek attack. About less than 2 weeks later, on the 19th of April 2004, he has walked 40 or 50 or so kilometers back to the east and again crossed the Achwa River. Between the 19th of April and the 21st of April, just 2 days, he walks at least 40 kilometers, crosses the Achwa River, and is southwest of Odek. The next coordinates we have for him are on the 27th of April, 2004. He has again crossed the Achwa River, and he is now, let's say, 20 kilometers north of Odek. This is 2 days before the attack. We don't have any coordinates for the 28th of April or the 29th or the 30th of April. The direction finding data tells us absolutely nothing about where he went during that time. The next coordinates we have are from May 1st. He is again a little more than 20 kilometers north of Odek. And I would emphasize, Your Honors, that he's on the opposite side of the Achwa River. So if you take the direction finding coordinates at face value, at some point, we don't know when, but at some point from the direction finding, at some point in these crucial 4 days when the defense have told us that it was impossible to cross the Achwa River, Mr. Ongwen has crossed it. Now, I won't go through each specific location after this, but I would note, Your Honors, that the coordinates for the 18th of May, 2004, place Mr. Ongwen less than 20 kilometers from Lukoti. The attack there happened on the 19th of May. And as the date of the Abok attack on 8 June draws near, Mr. Ongwen is in that area. I'll just click through the remaining dates into August as he crisscrosses this terrain. So to conclude on this direction finding question, again, we're not asking you to rely on this to convict Mr. Ongwen, but when you consider the defense argument, we ask you to take it in context, because this information suggests that Mr. Ongwen spent this entire period trekking back and forth across this area of northern Uganda, repeatedly crossing the Achwa River and covering hundreds of kilometers. Far from creating reasonable doubt, Your Honors, we believe this evidence is entirely consistent with the prosecution case. This brings me to my next point. which is Mr. Ongwen's location on the day of the attack. The defense have suggested that Mr. Ongwen was not near Odek on the day of the attack. He was 20 to 25 kilometers north, near Lapak. They rely on two pieces of evidence. The first is the direction finding, which we've just looked at. The second is witness D75. Your Honors, we addressed D75 in detail in our written submissions. I won't go over that again. But our position is that you should completely disregard his ODEC evidence as either fabricated or hopelessly unreliable. Whatever you thought of his evidence when he testified, though, I would emphasize that D75 is the only witness placing Mr. Ongwen near Lapak on that side of the Achwa River at the relevant time. Fully 10 witnesses place him on the Odek side of the river. Fully 10 witnesses saw him there shortly before or after the attack, or in some cases both. 5 witnesses saw him in or near the camp itself. 3 additional witnesses saw him at an RV before the attack or right after the attack. And 2 victims of the attack saw him after they were abducted. Thanks, Charlotte. The defense, of course, quibble with pieces and parts of the testimony of most or maybe all of those witnesses. They failed to acknowledge, though, that all of them placed Mr. Ongwen on the Odek side of the river, far away from Lapak, where D75 said he was. Another body of evidence which the defense would ask you to ignore are Mr. Ongwen's own reports of the Odek attack over LRA radio on 30th April and 1st of May 2004. And this is my next point. Mr. Gumpert has addressed the intercept evidence generally, so I'll limit myself to a couple comments about Odek. As a general matter, the defense challenged the reliability of the intercept evidence, and they echo some of those challenges in the Odek section of their brief. Excuse me, but a few things are noteworthy. First of all, as I said before, the defense relied quite heavily on the direction finding. And as I hope I made clear, the attributions of radio signals to commanders for direction finding purposes is the same attribution as in the logbooks. It's done by the very same intercept operators, some of whom testified in this case. Second, the defense themselves relied directly on the logbooks to suggest that Ochan Labon was the first person to take responsibility for the Odek attack. Now, we've addressed this claim in detail in paragraph 279 of our closing brief. I won't repeat that here, but the bottom line is, we submit, if you look closely at the underlying documents, it's clear that it was Mr. Ongwen, not Ochan Labon, who reported the attack. But again, I make the point, Your Honors, that where the defense will have you believe the logbooks are reliable if they think that it's good for them. Only when the logbooks incriminate Mr. Ongwen do they suggest that they're not reliable. I'd also note the defense speculate that Ben Achalam, another LRA commander, received a direct order from Coyne to attack Odek. But what do they base this on? They base this on an attribution of a call sign in a logbook and a brief snippet of an audio recorded intercept. And let me emphasize, there's not a shred of actual evidence of any such direct order from Coyne to Ben Achalam, but it's another example of the defense relying on the intercept evidence when they think it suits them. As Mr. Gumpert said earlier, we believe they cannot reasonably have it both ways. In any event, there is overwhelming evidence that the intercept evidence as to ODEC is reliable. The first point I would make relates to voice identification evidence. Fully 5 witnesses sat in this chair and recognized Mr. Ongwen's voice on those recorded intercepts. Unless I've missed it, the defense haven't addressed any of those voice IDs in their closing brief. Now, to be fair, they do suggest in other parts of the brief that the government intercept operators had a bias. Mr. Gumpert addressed this. But they don't grapple with the fact that former LRA witnesses recognized that ODEC tape. Certainly, Mr. Ongwen's own comrades in arms didn't have a bias against him that he suggests that the government witnesses had. And again, well, actually, I note that one of those former LRA witnesses remembered hearing this report back in 2004. So he didn't only hear a voice that he recognized, he heard a conversation that he recognized. He could remember it happening at the time. And defense witness D100 also recognized Mr. Ongwen's voice. Certainly, the defense don't suggest that he harbored some kind of bias against the accused. The fact is, all of these witnesses were well placed to recognize Mr. Ongwen's voice, and they all did so. When the defense complained about pauses in the tapes or improper handling, those, I would submit, are basically distractions from the fact that all of these witnesses heard Mr. Ongwen in his own words, with his own voice, accept responsibility for this attack. Trying to go slow, Your Honor. I'll come now to a point, a new point, which applies to the ODEC attack, but I think also more broadly. The defense, quite rightly, insists and emphasize that we have the burden of proving our case beyond reasonable doubt, and that's right. We have that burden, we embrace that burden, and we've met it in this case. But the burden of proving our case beyond a reasonable doubt does not apply to every little fact or every piece of evidence in the case. As the Lubanga Appeals Chamber said in the Lubanga Appeals judgment, and the Chamber's repeated this many times, the beyond reasonable doubt standard applies to the elements of the crimes charged and the elements of the modes of liability, the so-called material facts. All the other facts, subsidiary facts, are not subject to the beyond the reasonable doubt standard. Consequently, when the defense argued that the prosecutions failed to establish beyond reasonable doubt where the pre-attack RV occurred for ODEC, well, in a sense, they're right. If you had to find that location beyond reasonable doubt, well, the evidence probably wouldn't get you there. But the precise location of that RV is not a material fact. It was not alleged in the confirmation decision, and it is not subject to the beyond reasonable doubt standard of proof. What has been proven beyond reasonable doubt in relation to this RV is that Mr. Ongwen was in a perfect position to order that attack and to personally participate. As I stated earlier, 10 witnesses placed Mr. Ongwen at or near ODEC at the time in question. Several of those witnesses placed him at this RV, giving orders to his men, including orders to kill civilians. Several witnesses saw him after the attack, including 2 victims. And we even have the audio recordings of him reporting the attack. This is all the evidence you need, Your Honors, and all the certainty you need to convict Mr. Ongwen of the ODEC charges. The defense do make one more point, which I'd like to address. They don't only say that the precise location of the RVs is unclear. They say that some of those locations were just too far away from ODEC that it would have been impossible to reach Odek. But that's not correct. Mr. Ongwen, when speaking to his medical doctors, his defense experts, he said that after his abduction into the LRA, sometimes he would walk up to 35 miles a day in the rain without boots. That's 56 kilometers, Your Honor. P-54, who lived with Sinia Brigade in this very same area in 2003, testified that from Loyo Ajonga, one of the locations, it was a 6-hour walk to Odek. From Orapoyo, 4 hours. Now, in light of that evidence, Your Honors, which is entirely consistent with average human walking speeds, all of the prosecution witnesses placed Mr. Ongwen within a day's walk of Odek on the day in question. Your Honors, I don't have anything more specifically about Lukoti to say. I've touched on it a little bit. We've written quite a bit on it in our written submissions, and Mr. Gumpert addressed the intercept evidence earlier. So let me turn finally to the attack on Abok in June 2004. I'd like to make just 3 points. And the first concerns witness 252. At trial, Your Honors heard many witnesses testify about this attack and the crimes committed there. Much of that evidence is addressed in our closing brief. But one of those many witnesses was P252. And the defense have now suggested that he's not credible. Not because he intentionally lied, they don't say that. But they say he has a health condition which affects his ability to reconstruct memories. They also raise a specific concern about the amount of time he stayed in the LRA, or the date of his escape. On the first point, when P252 testified, his recollection was clear and consistent with other evidence. He showed no sign of any inability to remember what had happened to him, or to talk about it. And I'd emphasize that various aspects of his evidence were corroborated by 13 prosecution witnesses and 2 defense witnesses. I'll give just a couple of examples. Like P252, 3 other witnesses described a parade that took place before this attack, during which Mr. Ongwen issued orders and instructed his subordinate, Okello Kalalang, to select fighters and personally lead the attack. P252 also testified that the LRA fighters returned from Abok with maize, cooking oil, beans, and other food items. 4 prosecution witnesses and 2 defense witnesses gave similar accounts. P252 described LRA fighters coming back from the attack with abducted civilians who were bound at the waist. This account was corroborated by 9 prosecution witnesses and 2 defense witnesses. Now, insofar as P252's date of escape is concerned, there the prosecution agrees that he probably got that wrong when he testified. We explain at paragraph 72 of our closing brief that we think he left the LRA in mid-June 2004. But like several witnesses in this case, P252 had trouble remembering the month or even the year that certain events happened. And we submit that 15 years after the fact, and given the circumstances of his abduction, his stay with the LRA, and his eventual escape, that's not all that surprising. And it doesn't fundamentally undermine his credibility. To be clear, you don't need to rely on P252 to convict Mr. Ongwen of the Abok crimes, but on the evidence, you're more than entitled to do so. Turning to my second Abok point. A number of witnesses testified that Okello Kalalang was the LRA commander who Mr. Ongwen placed in charge on the ground of the Abok attack. The defense, in their closing brief, sort of twists that evidence to suggest that it was Kalalong himself who was in charge, who gave the instructions, not Mr. Ongwen. But this narrative is simply not supported by the evidence, even the evidence cited in the defense closing brief. For example, P330 told Your Honors that Odomi, remember that's Mr. Ongwen's nickname, was the overall commander, the person who ordered the Abok attack, and the one who issued instructions to Kalalong to select a standby. He also told you that after the attack, his superior reported to Kalalong, who reported to Ongwen, about what happened during the attack and what they'd taken. Witnesses P406 and P54 also testified that Mr. Ongwen appointed Kalalong to select and lead the fighters to the attack site. 6 different witnesses confirmed that Kalalong was subordinate to Mr. Ongwen. And of course, the intercepted report and logbooks confirm that Mr. Ongwen reported the attack to his superiors. All of this evidence shows, Your Honors, that it was Mr. Ongwen who gave the orders for the Abok attack, not Okello Kalalong. And finally, the defense claimed in their closing brief that the only instruction proven, according to them, for the Abok fighters was to collect food at the camp. And they suggest that, therefore, Mr. Ongwen should not be held liable for counts 37 to 49. But let us recall, Your Honors, what it means to collect food. When the LRA collects food, what is that about? Defense witness D105 told Your Honors quite frankly that collecting food meant taking it by force from civilians. Many witnesses told you that collecting food was done by LRA fighters armed with guns, bayonets, and machetes. Collecting food often meant attacking civilians in camps, and as witness P330 put it, committing atrocities. At Abok, in particular, it included shooting, stabbing, beating, hacking civilians to death when they hid or attempted to flee. It involved locking civilians inside their homes and setting those homes on fire. Even at its least violent, Your Honors, collecting food for the LRA meant breaking into civilian homes and shops, stealing their food, their clothes, drinks, money, even livestock. At Abok and elsewhere, it meant leaving those camp residents who weren't killed or abducted to face potential starvation and certain deprivation. That, Your Honors, is what it meant when the LRA went to collect food, and we think that you should understand it in those terms. That is the end of the prosecution's closing arguments. I thank you for your attention. We would ask you to convict Mr. Ongwen on all counts.
Thank you very much. That concludes today's hearing. We resume tomorrow at 9:30 with the closing statements by the representatives of the victims.
All rise. Vi får leva.